Hello, everyone. So today's question or challenge to ChatGPT is going to be a fun and interesting one. Not fun if you're in this situation, but the question is, can a U.S. permanent resident enter the U.S. if they have a marijuana conviction for possession? Just for possession. You're clearly inadmissible and deportable if it was a conviction for any type of distribution, sale, or manufacture of any type of drug, including marijuana. But for possession, it gets a little trickier. So I've asked this question to ChatGPT. Let me share my screen here and see what it says. Okay, I got the screen shared. So I've already queued up the question here. Let me just scroll down a little bit. Can a U.S. permanent resident enter the U.S. if they have a conviction for marijuana possession? And synonymous with this question is, can you travel internationally? If you're a U.S. permanent resident, can you leave and be expected to be let back in if you have a possession conviction for marijuana? So looking at the answer, surprisingly, ChatGPT gets this question flat wrong and suggests that they will be let in. And our immigration code is very clear. You are inadmissible, and a permanent resident is treated as somebody trying to re-enter the country only in some context. Generally, they're actually not treated as someone re-entering the country. It's not a, quote, entry once you're a permanent resident, like it's not for a citizen. It's kind of a legal term of art there. But if you have any certain criminal convictions, including any type of controlled substance offense, you are deemed asking to enter the country again. And so for any type of drug possession, and unfortunately with our federal laws on controlled substances, marijuana is still considered a Schedule I, which is the highest order of controlled substance up there with heroin and kind of other types of drugs that have no medical purpose. That's outdated, and obviously many states, including Colorado, vehemently disagree with how marijuana is categorized, but we are controlled in terms of U.S. immigration by federal law. So this first answer is patently wrong. They should not, per the law, they should not let a person back in, and they'd have to actually get a waiver if it's just a one-time conviction for marijuana possession. If it's something more significant, they may not even be eligible for a waiver. Now, I will say discretionarily, I don't know where that discretion comes from because the law is really clear. I did have one client let in without having to get a waiver who had used and convicted in Texas of using a THC cream. It contained THC, not CBD. And he discretionarily, they actually did let him in, but I don't think you can expect that. So I want to flesh this out a little more. Do I need a waiver to enter the U.S. if I have a conviction for marijuana possession? Let's see if it gets this one right. It's generating the response now. So interestingly, ChatGPT does not really understand the waivers for marijuana for one conviction for possession of marijuana, both a deportability ground and an inadmissibility ground, meaning a ground to keep you out and a ground to kick you out is any type of controlled substance offense, with one exception. You can get a waiver if you're trying to enter the country if you only have one possession of less than 30 grams of marijuana. And you're not deportable, they won't kick you out if you only have one conviction of less than 30 grams. If you need the waiver, you need to meet certain standards, which it doesn't flesh out here. So this does show that ChatGPT's database, or where they're pulling all their data to then create their AI responses, is lacking in this particular area. From this question and answer with ChatGPT, I would give it a 2 out of 10, since I'm less impressed than I normally am with this one. Okay, everyone, thanks for watching. I know this was a longer one, but I think it was an interesting one, I hope. So until the next one.